Hello, good morning. I'm Srinivas. Now I'm discussing about Hindu Succession Act 1956. Salient features of Hindu Succession Act 1956 came into force on 17th June 1956, the day which received the assent of the President, published in the Gazette of India, Extraordinary, Part 2, dated 18/6/1956. The following are some of the distinguishing features of Hindu Succession Act 1956. The Hindu Succession Act 1956 extends to whole of India except the state of Jammu and Kashmir, Section 1. But now, because the Jammu and Kashmir is also included, as Article 370 was taken away recently by the Parliament of India. The Act applies to all Hindus, including Veerashaiva, Lingayat, are members of Brahma, Prarthana and Arya Samaj, Buddhists, Jains and Sikhs, but not to Muslims, Parsis and Jews. It has further been extended even to those persons, one of whose parents is a Hindu, Buddhist, Jain and Sikh. The Act has overriding effect. It abrogates all the rules of the law of succession, hitherto applicable to Hindus, whether by way of any text, customs or usage, having force of law. The concept of succession. The succession means inheriting of a title, office or power from one after another in time. Testamentary succession, the process of distribution of property when a person dies by making a will. A will or testament is an instrument or document which declares the intention of the owner of the property as to how the property is to be distributed after his death. Second one is intestate succession. When a person dies without leaving a will, his property will be distributed by operation of a particular law. The process is called intestate succession. The Act shall apply to all intestate Hindu succession except to the property of a person to whose marriage provisions of the Special Marriage Act 1954 apply. And number 2, to the importable estates of the rulers of the Indian states, succession to which is regulated by special covenants and agreements or existing enactments. Section 5. The Act will also not apply to Mitakshara co-parcenary property except when a co-parcener dies leaving female heirs mentioned in Section 6. The Act has opened the right to succeed to certain females to the interest of a deceased in his co-parcenary property. The separate provisions for the devolution of interest in the property of a Tawad, Tawazi and Kutumba, Kavuru and Ilom have been provided. Section number 7. The Act lays down new provisions for devolution of property of a male Hindu dying intestate. Section 8. The Act provides the order of succession among heirs in the schedule. Section 9. Rules relating to distribution of property among the heirs, Class 1 legal heirs of the schedule, Section 10, and among the heirs of Class 2 of the schedule, Section 11. Rules of order of succession among agnates and cognates, Section 12, and method of computation of degrees, Section 13. The Act has abolished Hindu women's limited estate and made her absolute owner of the property irrespective of its source of acquisition. Now, objective and applicability, section number 2. Objective: to attend and codify the law relating to interstate succession among Hinduism. Applicability: it extends to whole of India except the state of Jammu and Kashmir, section 1. But however, due to removal of this article 370 recently, this exception may not be applicable now. The Act applies to all Hindus, including those Veerashaivas, Lingayats, and members of Brahma Samaj, Prarthana Samaj, and Arya Samaj. Buddhists, Jains, Sikhs, but it is not applicable to those of Muslims, Christians, Parsis, and Jews. It has been extended to those persons one of whose parents in Hindu, Buddhist, Jain, or Sikh by religion, or both parents are Hindu, Buddhist, Jain, or Sikh by religion. Who is a convert to reconvert to Hindu, Buddhist, Jain, or Sikh religion? For all these, this particular act is applicable. The Act lays down some of the general rules of succession in case of Section 8. As per Section Hindu Succession Act 1956, if a Hindu male dies without a will, then the property would be distributed. Firstly, among class 1 heirs specified in the schedule. Secondly, if there is no class 1 heirs, then among class 2 heirs specified in the schedule. Thirdly, if there is no class 1 and class 2 heirs, then among the agnates of the deceased. And lastly, if there is no agnates, then among the cognates of the deceased. The right of the child in the womb at the intestate's death and subsequently born alive shall relate back to the date of intestate's death, section 20. Where two persons have died in circumstances rendering it whether either of them, or if so, survived the other, then for all purposes affecting succession to property, it shall be presumed until the contrary is proved that the younger survived the older, section 21. Where property of intestate devolves upon two or more heirs, and any one of such heirs propose to transfer his or her interest, the other heirs shall have a preferential right to acquire the interest proposed to be transferred, section 22. The right of residence to a female heir in dwelling house of the intestate family is given if she is unmarried or married but discarded or a widow, section 23. This section has been deleted by Hindu Succession Amendment Act 2005. A murderer has been disqualified from inheritance on the grounds of justice and equality. This is explained under section 25. A convert's descendants have been disqualified from inheriting the property of their Hindu relatives unless such descendants are Hindus at the time when the succession opens, section 26. The convert himself, in view of the Caste Disabilities Removal Act 1850, however, will not be so disqualified. If any person is disqualified from inheriting any property under this Act, it shall devolve as if such person had died before the intestate, that is section 27. No person shall be disqualified from succeeding on the ground of any disease, defect, or deformity, or any other ground not provided in the Act, that is section 28. If an intestate has left no heir qualified to succeed to his or her property in accordance with the in accordance with provisions of this act, such property shall devolve the government, and the government shall take the property subject to all obligations. Now, class 1 heirs. Hindu male dies without a will. If a Hindu dies intestate, the class 1 heirs, this schedule is shown as below. Widow, second will be mother, third son, daughter, fourth son, daughter of a predeceased son, fifth son, daughter of a predeceased daughter, sixth widow of a predeceased son, son or daughter of a predeceased son of a predeceased son, widow of a predeceased son of a predeceased son. Now, number 9 is shown in blue color hereafter. It is because it is added by the new act number amendment that has been taken place, Act number 39 of 2005, which is effective from 9/9/2005. Son of a predeceased daughter of a predeceased daughter, daughter of a predeceased daughter of a predeceased daughter, daughter of a predeceased son of a predeceased daughter, daughter of a predeceased daughter of a predeceased son. So these are all the class 1 heirs as per the schedule. Now this amendment of 9/9/2005 is also included here with the blue color. Now coming to the section 30, a male Hindu is entitled to dispose of by will his interest in a Mitakshara compulsory property. In the schedule of the Act, lists of heirs in Class 1 and Class 2 are given as explanation in Section 8 of the Act. Major changes have been made in Act through Hindu Succession Amendment Act 2005. Fundamental changes brought by the Hindu Succession Act 1956. There were two schools in whole Hindu law, namely Mitakshara and Dayabhaga, governing the Hindu succession. However, the Hindu Succession Act 1956 brings all the schools into a uniform system. In old law, there was a distinction between male and female heirs, but Hindu Succession Act 1956 makes no distinction between male and female heirs. Under the old law, the rule of preference is based on right to offer pinda or propinquity of blood. But the order of succession provided by the Act is based on the concept of love and affection. Now, Class 1 heirs are described here by a small chart. Basically, if I take the number 1 position comes the deceased who died intestate, that is no testamentary will or will is not there. Then the first option goes to widow, second preference goes to mother, third goes to son or daughter, fourth goes to son, daughter of a predeceased son, fifth preference will be son or daughter of a predeceased daughter, and number 6, widow of a predeceased son. Now coming to the next level, that is son, daughter of a predeceased son of a predeceased son, and 8, widow of a predeceased son of a predeceased son. Now, as I told you, there are some changes which has been brought under this blue color, that is son of a predeceased daughter of a predeceased daughter, and daughter of a predeceased daughter of a predeceased daughter. Now, If a Hindu male dies without a will, distribution of property among class 1 heirs, section 10 is describing about the priority. The widow or widows, mother next, and each of the children, son or daughter. The law makers to distinction, section number 6, take equal shares. Where one or more of such sons or daughters is no more, then the class 1 heirs in that branch will all jointly stand in place left behind by each deceased son or daughter, and that take between them one shares. Note, here is a small note that is explaining if there are more widows than one, all the widows together shall take one share. Now, in case there are no relatives as per class 1 is available, then the property will be distributed among the class 2 heirs. So this is what the Hindu male dies without a will, that means intestate succession is by laws explained in section 10. Now class 2 heirs, firstly father, then second sons, daughters, son, daughter, brother and sister. Third position, daughters, son, daughter, daughter's son or daughter, son or daughter of a this one. Brothers, fourth position, brother's son or daughter and sister's son or daughter. Father's father or father's mother, father's widow and brother's widow. Then seventh place, father's brother or sister. Next comes eighth position, mother's father or mother. Now ninth position, mother's brother or sister. Explanation: in this schedule, references to a brother or a sister do not include reference to a brother or sister by uterine blood. Now, the fundamental changes I was talking about earlier. In old law, there was a distinction between male and female heirs, but Hindu Succession Act 1956 makes no distinction between male and female heirs. Under the old law, the rule of preference is based on right to offer pinda or propinquity of blood, but order of succession provided by the act is based on the concept of love and affection. Now, let us come to the class 2 heirs, how they actually come in priority. First priority will be the father, then second is son's daughter's son or daughter or brother and sister. Third position, father's father. Then the next priority goes to brother's son or daughter and sister's son or daughter. Next priority goes to daughter's son or daughter, daughter's daughter, daughter's son or daughter's son. So these are all class 2 heirs, and exactly after this you have to prioritize the order of succession. Here father's widow and brother's widow. Next comes class 2 heirs, if we want to discuss the order of succession among class 2 heirs, section 9, the heirs in the first entry in class 1 shall be preferred to those in the second entry. The heirs in the second entry that will be preferred to those in the third entry, and so on and so forth in succession. For example, if the father is no longer alive, then the second of such as son's daughter's son, son's daughter's daughter, number 3 brother, number 4 sister will get the property in equal measure, provided all the heirs are available. So however it will be the property in equal proportion. Distribution of property, it will be first father. Now this blue color is the amendment. Son's daughter's son, daughter's son, then daughter's sons and daughter or daughter. So like this the succession will take in class 2 heirs. Succession among the agnates. Next, if nobody is available in class 2 heirs, now the priority goes to succession among the agnates, that is explained under section 12 of the Hindu Succession Act 1956. A male or female descendant by male links from a common ancestor or relatives through male linkage are called agnates. And it is also important that ascendant agnates are always preferable than descendant agnates. See, here is one graphical representation wherein the ascendant agnates are there. That is the second, whatever is shown in the blue color is the class 2 heirs, and there is one ascendant agnates are there specifically told, that is deceased who has died intestate succession. It goes first to son, then to his next son's son, next son's son's son, next son's predeceased son's son, then like that. However high may be, the ascendant agnates will get an edge over the descendants. Now succession among the cognates, section 12 of the Hindu Succession Act 1956 talks about cognates. One person is said to be a cognate of another if the two are related by blood or adoption but not wholly through the males. There should be a linkage of one female in link. If there are no cognates too, then all the property of the deceased person will go to the government. This is called doctrine of escheatment, section 29. The question of escheat arises when a Hindu intestate has left no legal heir. When the intestate has left a heir who is statutorily disqualified from succeeding, that is section 25 to 28 of the Act. And here is a graphical representation where the cognates are defined, where the deceased mother's mother, however high may be, she would also get a cognate position. The blue color are shown to class 2 heirs, and the yellow color determines the cognates in succession. Then Hindu female dies without a will, then the property of the female Hindu to be her absolute property as per section 14. If a Hindu female dies without a will, her property, if she is the full owner of the property, the distributed as follows. Firstly, upon the sons or daughters, including the children of a predeceased son or daughter and husband. Now, secondly, upon the heirs of the husband, and thirdly, upon the mother and father of the female intestate. Then, fourthly, upon the heirs of the father, and lastly, upon the heirs of her mother. Now, under section 14, property includes both movable and immovable property acquired by a female Hindu by inheritance or desire or a position or in lieu of maintenance of a son of a. Then other important provisions. Any person who commits murder or abates the murder shall be disqualified from acquiring any form of property, inheritance from the victim. That is section 25. Full blood is always preferred to half blood. That is section 18. It is a person converts from Hinduism, he is eligible for the inheritance, but in our descendants be disqualified for inheritance. That is section 28. A child in womb at the time of death of intestate shall have the right to inherit if a child is subsequently born alive. That is explained in section 29 of the Act. In Minot versus Sushal Mohan Singh case 1982, the will should used in section 25 Hindu Succession Act 1956 includes culpable homicide or murder. The other important provisions, thus as per discussion held in the previous slides, the following are disqualified from inheriting the property of the deceased intestate. That is murderer, section 25. Number 2, abater to murder, section 25 again. Then converts descendants, section 26. These provisions is made to prevent those who are acquitted or convicted in murder cases. Now, salient features of Hindu Succession Amendment Act 2005. Object of amending the Act 39 of 2005. The Hindu Succession Act 1956 as amended and codified the law relating to intestate succession among Hindus. The Act brought about changes in law of succession among Hindus and gave rights to which were till then unknown in relation to women's property. However, it does not interfere with the special rights of those who are members of Hindu Mitakshara coparcenary, except to provide rules for devolution of the interest of a deceased male in certain cases. The Act lays down a uniform, comprehensive system of inheritance and applies to the persons governed by Mitakshara and Dayabaga schools. Now, other important provisions are made. Any person who commits murder and abets the murder shall be disqualified arriving any inheritance from the victim. This one is explained earlier. Now, coming to the salient features of Hindu Succession Amendment Act 2005. This section 6 of the Act deals with the devolution of interest of a male Hindu in co-passionary property that recognizes the rule of devolution by survivorship. Among the members of the co-passionary, the retention of Mitakshara co-passionary property without including the females in it means that the females cannot inherit in ancestral property as their male counterparts do. The law, by excluding the daughter from participating in the co-passionary ownership, not only contributes to a discrimination on the ground of gender, but also led to apprehension and negation of her fundamental right. Fundamental right of equality guaranteed by the Constitution, having regard to need to render social justice to women. The states of Andhra Pradesh, Tamil Nadu, Karnataka and Maharashtra have made necessary changes in the law giving equal right to daughters in Hindu Mitakshara co-passionary property. The Kerala legislature has enhanced the Kerala Joint Hindu Family System. With this, I will